This is Duke University.
Well, good afternoon. My name is Neil Siegel, and on behalf of the program in public law here at Duke Law School, I'm very pleased to introduce today's event with Michael Dreeben. He will speak to us on the challenges and rewards of representing the interests of the government of the United States before the Supreme Court of the United States. And he will be interviewed by his criminal law teacher and yours, Professor Sarah Beal, who has influenced many a graduate of this law school, including Michael Dreeben. He's a 1981 graduate of Duke Law School, and in my opinion, one of this law school's most distinguished graduates. He is the Criminal Deputy Solicitor General of the United States, in which he helps to supervise the government's litigation in criminal cases in the federal courts, as well as in the U.S. Supreme Court. I had the honor of working for Michael for a year at the Office of the Solicitor General, and it was apparent to me very quickly that not all advocates are similarly situated with respect to the degree of interest they trigger in the justices. Right? The advocacy is of uneven quality, and some are better at it than others. And what struck me about Michael's arguments is not just the poise and the confidence and often the lack of notes, but the frequency with which each of the justices would sit forward on their chairs as he spoke. They were intensely interested in what he had to tell them. He has unmatched credibility before the court, I think unmatched knowledge and intelligence about what the government's interests in criminal litigation are, and it shows. He is truly one of the very best Supreme Court advocates in our country, in our constitutional system, and we at Duke Law are very proud to call him one of our own. Without further ado, I'm going to turn the proceedings over to Professor Beal, who's going to have a conversation that I'm sure will enlighten all of us.
Thank you, Neil. Well, Michael, Neil has told us that once upon a time you were back in those rows where those students are sitting now. Can you tell us a little bit about how you made your way to the Solicitor General's office? What were the steps? How did you think about that?
Thank you very much, Sarah. It is a pleasure to be here today. It's a pleasure to be talking to law students who are sitting in much nicer quarters than where I once sat, but similarly situated. During law school, I heard of the Solicitor General's office first from Sarah Beal, who is an alum of that office. It was the first encounter that I had had with the fact that the government had a specialized office that represented the United States in the Supreme Court. I knew that anybody who was in that office had to be extremely impressive because Professor Beal was extremely impressive.
He's good with compliments, yeah.
and exposed me to new angles and ways of drawing interconnections between different areas of constitutional law. And this seemed like a remarkable experience that she'd had. It really didn't come home to me about how remarkable it was until I was sitting in the law library picking up a volume of the U.S. reports in the days when we did our research based on paper documents rather than computers. And I opened the page and saw that there was a case that I was reading, very critical for the issue that I was working on. And Sarah Beal's name was there as the counsel who had argued the case. And I was even more impressed at that point with Professor Beal than I had been previously. But my own road to Solicitor General's office was very circuitous. I didn't actually intend to be an appellate lawyer after I graduated from law school. I clerked on an appellate court, but then I wanted to do something in the real world, like take depositions and review documents.
That does sound exciting, yeah.
It was a thrill. And it lasted for long enough to have blunted the sense that I had that I actually knew what was going on in the law. When you graduate from law school, you feel like you're very up to date and you know what's going on. After a few years in the trenches, I would read a Supreme Court case about once every 2 years. I felt very much out of it. And it was only by virtue of the fact that I had two friends who were in the Solicitor General's office who encouraged me to apply that I found my way back to doing appellate law. Now, I had a very rarefied, abstract, and inaccurate view of what the Solicitor General's office was when I went to apply to it. I had formed the impression, and I'm not sure where I formed it, that the Solicitor General operated as a free legal agent in the government, capable of relaying to the Supreme Court the best understanding of the law that the Solicitor General had, regardless of any other institutional concerns in the United States government. I even pictured it in an office off by itself in some building separate from anybody else's influence. That all turns out to be rather incorrect. The Solicitor General's office is in the Justice Department physically and as a matter of institutional reality. The Solicitor General's boss is the Attorney General. The Attorney General reports to the President, and no Solicitor General ever forgets that. But I did find that the office was a remarkable place, and I was thrilled when I got the opportunity to join it.
So you talked about it being a remarkable, a special place. Some people have talked about it being the 10th justice and so forth. Can you talk about what it is that the SG's office does, even though it's not a free agent, its role is unusual?
The Solicitor General has the responsibility of representing the United States government in the Supreme Court. And the United States government is really a far-flung legal enterprise. In the area that I now supervise, criminal law, there are 92 United States attorneys' offices around the country. The criminal division...
I thought it was 93. Guam lost its office or something?
No
we don't know.
Comment on it.
No comment on it. Okay, never mind. 92 to 93, I'm thinking he's probably right.
Plus main justice. So you have a number of different actors who go into court and represent the United States in criminal cases. By the time an issue reaches the Supreme Court level, however, the justices and the government benefit from hearing from one voice to articulate the legal position of the United States. And that often requires resolving differences that may exist between advocates who are representing the United States in New York and the advocates who are representing the United States in San Francisco. Short-term interests may drive the legal positions of individual prosecutors, but the Solicitor General's role is to look out for the long-term interests of the United States, which may mean compromising legal positions, taking more limited stances than aggressive trial prosecutors have seen fit to take in the lower courts. And so the Solicitor General, a very small office consisting of about 22 people, has the task of trying to reconcile all of the government litigation that flows up to the Supreme Court. The phrase, the 10th justice, is an attempt to capture the idea that the Solicitor General has a special relationship to the Supreme Court that differs from other advocates. In one sense, that is undeniably true. Representing the United States government in the Supreme Court is to represent a unique client, part of the government itself, the most powerful nation on earth, with the most diverse legal interests. But part of the idea behind the 10th Justice is that the Solicitor General owes a duty of unflinching candor to the court about legal policy and factual issues. The Solicitor General is an advocate, and the United States takes aggressive legal positions. But in the briefs that we file with the Supreme Court, we make every effort to be scrupulously accurate and candid about both the points that help us and the points that hurt us. And we do this so that the court can rely on a filing from the Solicitor General as being the best, credible, accurate job that the lawyers in the office can accomplish.
Well, there's also a gatekeeper function, isn't there, in terms of what issues are going to move up in the federal court system? Can you talk about that? Because I think that has, the court looks to you for that function as well.
It's certainly true that there are many demands on the court's time and attention, and if the Solicitor General's office did not exist to channel government litigation, every losing litigant would believe naturally that his or her case merits Supreme Court attention. and the court could be deluged with petitions for certiorari from every government agency, every United States Attorney's Office, every component of the Justice Department, and that would not serve either the court or the government very well. It wouldn't serve the court very well because the court would lose the benefit of an objective appraisal of which cases really merit its time and attention from the government. It would have to undertake that task itself. And even though the court could perform that task, it would actually hurt the government if the government required the court to do it, because then the government would lose some litigation control over which cases it believed the court should hear, which are the most important cases, which are the best vehicles for developing law.
Yeah, let's talk about that, because you are not only trying to serve the court in the sense of narrowing its docket, but all along and with appeals at the lower level, you're trying to bring forward certain issues that the government thinks are important in certain, you talked about a vehicle, we're not talking about a car here, we're talking about something a little different. So can you explain, I'm guessing the folks out there really have no idea of the volume that we're talking about and the shaping role that the SG's office plays.
Well, let's talk about that in the criminal law area, because I'm most familiar with that. Every year, United States attorneys indict, namely charge criminal defendants in about 80,000 cases. 80,000 cases or so are commenced in the district courts. Many of them are resolved under plea agreements and wash out of the system and trigger no further appellate proceedings. But about 10,000 of them end up in the courts of appeals. Most of those are on appeals by defendants. Some of them are on appeals by the government. Before a United States attorney can appeal to a court of appeals, there is a review process that culminates in a decision by the Solicitor General either to authorize appeal or not authorize.
And if they're criminal cases, those go through you.
Yes, so all of the cases in which the United States attorneys want to appeal, there will be a memo written by the U.S. Attorney's Office, memos written in the criminal division, and memos written in my office, and it will ultimately be reviewed by me, and then a decision will be made by the Solicitor
So
General.
what kinds of cases are those where you're looking at you as an appellant rather than trying to defend a conviction? Can you give us some examples?
Typical case would be a court throws out evidence based on a failure to give Miranda warnings, and there may be an issue about whether the warnings were adequately given, whether the defendant was actually in custody, which is the circumstance that triggers the Miranda warnings. There may be a question about whether there's an exception to Miranda that applies under the circumstances. A district court will find facts, make rulings of law, rule against us, and then the question will be, should the United States appeal? In cases where the only dispute is over what happened, namely what the facts are, we are much less likely to appeal than the U.S. Attorney's Office will want us to. The U.S. Attorney's Office will say, we were robbed, we would like to take an appeal.
And do they yell when they're saying that?
We make a strong effort to have a fully professional, team-like dialogue. And yes, emotions sometimes get out of hand, but there is a real effort to make sure that the Solicitor General's office doesn't appear to be issuing what one prosecutor once told me, papal bulls coming on high with no discussion. I am a firm believer in the idea, in general in the law, as in life, but specifically in the Solicitor General's office, that things are done best when they are discussed on a collegial, eye-to-eye basis with mutual respect. And so even though we have the power to say no and to do it as peremptorily as we would like, we never do that. If I think that a case should not be appealed because there's a messy factual issue that we're not going to win on in the Court of Appeals, or because the case has very hard facts for us and will make a very difficult case to sell the legal proposition, I or someone in my office will pick up the phone and call the prosecutor and tell the prosecutor why, and we'll say, what do you think? And hear from the prosecutor. Sometimes their minds are changed by this conversation, sometimes my mind is changed. Even when it's not, that kind of dialogue, I think, is essential to the smooth functioning of the Justice Department. Now, we have limited success and limited control over channeling government litigation to the courts of appeals because the Solicitor General only sees the case if the United States has lost in the district court. If the United States has won, the United States Attorney can defend that conviction or sentence in the Court of Appeals without any intervention from Main Justice. And as a result, we are only seeing and controlling half of the process, which leads to the need at the Supreme Court level for the Solicitor General's office to try to impose consistency on government positions. We can find ourselves in cases where the United States Attorney has prevailed in a position in one court and then the opposite position in another court. It falls to our office to reconcile those two positions.
So do you sometimes confess error in a situation like that?
We do, and this is another unique thing that the Solicitor General does. It's not true that no other litigant does it, but usually if you have a paying client, the client does not enjoy paying you in order for you to tell a higher court that it was wrong that you won. The United States is different, though. There is a practice called confession of error, and that occurs when the United States has won a case in the lower courts, and the defendant, it's usually a criminal case, the defendant seeks Supreme Court review, and after conscientious study and discussion, sometimes heated, but always thorough, the Solicitor General will conclude that the government won, but it should not have won.
Can you give us some examples of that? Because I think it's a little hard to kind of grasp sitting out there. This all sounds very abstract.
Well, the most dramatic example of that was Dickerson versus United States, the case in which the court considered whether to overrule Miranda. In that case, the Court of Appeals for the Fourth Circuit had read the entire corpus of Supreme Court Miranda decisions and decided that Miranda was not really a constitutional rule of law. And as a result, a federal statute, 18 U.S.C. 3501, which provided for the admission of voluntary confessions, had displaced Miranda. And it therefore admitted statements into evidence for purposes of a criminal prosecution when no Miranda warnings had been given under the circumstances. When that case reached the Supreme Court, the Department of Justice undertook one of the most intense internal reviews of a legal issue in any situation that I've been involved in. All the United States attorneys were permitted to weigh in, all of the federal law enforcement agencies, all of the components of the Department of Justice. The decision actually went up through the Attorney General to the President, and it was ultimately determined that the United States would not urge that the Supreme Court overrule Miranda, that it would view Miranda as a constitutional decision, and under those circumstances agree that the statements should not actually be admitted into evidence on the theory that the Fourth Circuit had adopted. That was a fairly extreme example of confessing error, and I think that it's worth pointing out in a footnote to that that the Supreme Court did agree with the government's view by a 7-2 vote. Ultimately, the case went back down to trial. Dickerson himself was a bank robber who had made various false exculpatory statements saying that he wasn't anywhere near the scene of the crime. He decided to testify at his trial, and once you testify, you can be impeached with statements that were taken in violation of Miranda. So the statements were actually admitted into evidence, and he was convicted. That might be described as a happy ending for a confession of error.
Not for him, but for the government, yeah.
For justice.
For justice.
And more conventional examples of confessions of error will simply be where a lower court has overlooked a governing Supreme Court precedent, or where the facts of the case were misunderstood by the lower court, and in reality, something quite different happened than the court had assumed. This is a rare thing that the SG does, but the fact that the Solicitor General will confess error 2 or 3 times a year is a way of saying that, look, we're standing behind all of the other judgments that we're defending in this court. The ones where we're letting it go are the indications to you, Supreme Court, that we are really looking carefully at this and not just reflexively defending anything that the lower courts have done.
Yeah. So give us a sense of the volume of cases that you're dealing with. You start out with that 80,000, but that, you know.
The 80,000 winnows itself down pretty quickly to the 10,000 or so cases that are in the courts of appeals. Of those, I would say that somewhere around 1,000 cases will flow through the Solicitor General's office from the lower courts in the criminal context in any one year. Some of those require an enormous amount of work. We have to file briefs in opposition to petitions for certiorari. Other cases will be handled on a much more routine basis. The decision will be made not to appeal. It will be unanimous. Memos will be written, but they don't take that much time to review. Mm-hmm. The most time-consuming, demanding, rewarding, challenging, and sometimes terrifying aspect of the job is preparing the merits briefs for the Supreme Court and then arguing them in the Supreme Court. The Supreme Court has settled in on a relatively small docket these days of around 80 cases a year. It happens to coincide with the Supreme Court hearing 2 arguments in the morning on every one of its scheduled argument days. In the days when Sarah was in the office, it was much more typical that the Supreme Court would hear 2 arguments in the afternoon. But I think that they've now decided that this current schedule that they have works better for them. Yeah. The criminal docket is usually around a 4th to a 5th of the Supreme Court's overall docket. So that means that we're briefing and arguing 16 to 18 cases a year in the criminal area, and my office as a whole is briefing and arguing perhaps 55 to 60 cases, the lion's share of the court's docket.
That's what I was going to say. That's part of why they're the 10th justice, because they participate in such a high percentage of its cases. Okay, so what we really want to hear about is this cool stuff of you as an advocate in the Supreme Court. So how many cases have you argued, Michael?
I have now argued 77 cases.
77 in the Supreme Court. And how many in the Courts of Appeals? Because you also argue en banc cases in the Court of Appeals.
I've argued en banc in 9 of the 12 regional circuits.
He's still missing a few.
Still missing a few. I'm trying to complete that en banc bingo, but it's difficult because the Courts of Appeals don't sit en banc all that often. And usually when they do, it's a large honor for the lawyers who handle the case to argue it. I get drawn into the cases usually when they have some sort of preeminent national importance, and I'm either assigned to do it or it just seems like it's the right thing for me to go out and do it.
Well, so let's talk about briefing and arguing the cases in the U.S. Supreme Court. And you want to talk a little bit about briefing, and then I think the thing that's really exciting to listen to is some discussion about preparing for the argument and doing the argument. So what do you think these students should know about what that process is like?
The brief writing process is really the most important part of the decision of any appellate case. Courts of appeals rely far more heavily on briefs than they do on oral arguments, and the quality of a brief can make or break a case. It is certainly true that a court can do the research, read the record, and figure out what it thinks the right answer is without the aid of the parties, but in the American judicial system, it is an adversary process, and the briefs tend to shape very strongly the way that the court sees the case. Every brief should strive to be as candid and as accurate as possible. The SG may have a unique ability to be candid in that it's written on the Justice Department. The United States wins its point whenever justice is done in its nation's courts, meaning win or lose. We get to go home either way. Our client has been served because justice has been done. But any advocate representing any client should always remember your credibility is on the line. Anytime that you put your name to a brief, anytime that you stand up in front of a court, the most important asset that you have as an advocate is your credibility. You build it over a career, and you should start from the very beginning of thinking of building that credibility in the way that you write your briefs. Briefs should also be as clear as possible and as short as possible. Appellate judges have a lot to do. They are not interested in reading any more words than they have to.
Even in the Supreme Court?
Even in the Supreme Court, a brief benefits from being honed down to the essential points that it needs to make, and to apply a test really to every sentence, every paragraph, every section. is this necessary to the court's proper disposition of the case?
So do you get a draft comes to you? You don't start out at your stage of the career. You're not down there at the word processor for the first draft, right? So a draft comes to you.
Sometimes I am.
You are?
Sometimes I am.
Yeah.
We had a case in the Supreme Court called Sell versus United States. It had to do with whether a criminal defendant could be involuntarily medicated to render him competent to stand trial. I was just finishing up my second moot court, which is the last stage in my preparation process for an argument that was to be held about 3 days later. And the court issued an order, which someone came running into my moot court and handed me, that said, the court wants to know whether it has jurisdiction over the appeal in this case. And because I was arguing it and we had only 3 days to go, I sat down and I actually wrote the brief, which we filed in 2.5 days later. But in most circumstances, the solicitor...
Did you go home during the 2.5 days?
I did it at home. It was easier to pretend to sleep.
Yeah, well, and there was no driving time. You could just
right.
sort of plug yourself in. Yep.
That's right. Usually, the Solicitor General's office gets a draft from one of the divisions. We sit on top of a pyramid of extremely excellent appellate lawyers, and we work very closely with them, and we could not survive without that integration of functions. So a draft almost always arrives in the Solicitor General's office from a lawyer in the criminal division in the case of criminal appeals. It then is edited by one of the assistants to the Solicitor General, which is the position that I started out in the office. These are the generalist staff lawyers who are appellate experts, Supreme Court experts, but not necessarily subject matter experts in any particular area. They work across the Supreme Court's docket.
And that's what you did before you became deputy?
Yes. I mean, among the areas of my subject matter specialization were immigration law, the Interstate Commerce Commission, an agency who went out of business shortly after we won 6 or 7 cases in a row for it, and a few smatterings of criminal law, but I didn't have a comprehensive grounding in any particular area of law. The assistants are great because they bring to the table the same perspective that the Supreme Court has. The Supreme Court, for the most part, does not consist of justices who are experts, true subject matter experts in any one area, although some of the justices on the court today, I think, certainly are. They are therefore able to take the material from the agencies that are steeped in the minutia of the law and translate it into a form that's intelligible to generalist judges. Their work product then comes through one of the 4 deputies in the office who are subject matter specialists, and we are able to see interconnections within the areas of law that we're responsible for and hopefully weed out any last mistakes based on someone's lack of true familiarity with the area of law. We're sort of the catcher in the rye for our subject matter areas. Whether it works or not, that's at least the assigned responsibility.
Okay, so you filed the briefs. Now you're preparing for oral argument. Tell us about that. So you know you're going to be sitting, standing closer than, well, I don't know, about as far, Brian's farther away from you than you would be in the court, right? It's very close. It's very surprising how close you are.
The Supreme Court is a very intimate court. The bench it has a flat part in front where 3 justices sit, and then 2 wings that come off at an angle where 3 justices sit on each side, and the advocate is in the center of that. When you're in the Supreme Court room itself, it seems like an extremely grand and public space. Very high ceiling, marble friezes around the wall with images of justice from around the world and from across history. Statuesque marble columns, a huge clock at the center of the wall above the justices, and a gallery at which hundreds of spectators sit. And it's intimidating and awe-inspiring at the same time. When you stand up to argue, however, everything disappears except you and the justices. You can see them quite clearly. You can see their facial expressions of either you're selling what you're trying to say or you're not selling what you're trying to say very clearly. So the communication works quite well, and the rest of the world drops away, except when the justices make a joke, and then you can all of a sudden the gallery bursts out in laughter, and you're reminded that you're not alone there.
Right. So talk about your preparation and what it's like to argue before the court.
My preparation always follows pretty much the same sequence. I do all of the reading and writing that you normally would expect to do. You read all of the cases, you read the briefs, you write down questions that you expect that you might get answered, get asked when you're appearing before the court. And then I usually try to detour into a conversational phase where I seek out people who may or may not be lawyers, but they are intelligent observers of the legal scene.
Is this like your wife and children, or?
Actually, my best sounding board when he was alive was my dad. My dad was a chemist. He was not a lawyer, although he has 2 children who are appellate lawyers for the government. And he had an excellent sense of both nuance and overview. And what I had to do when I explained a case to him was boil it down to its essentials and make it comprehensible in a way that avoided legal jargon. And that forced me to simplify the case and to try to get to its essence. And then he would ask me questions, and oftentimes they were questions that had immense common sense appeal, but had eluded me because I had been reading too many Supreme Court cases and focusing on this 3-part test or that doctrinal twist. And that process actually greatly improved, I think, my ability to get to the heart of a case in a short period of time. My current favorite sounding board is my 14-year-old daughter, who just started high school.
And she sat in on the class.
She did. She came to our class. She and I had discussed intensely the moot court problem that is going to serve for the Dean's Cup and that is serving for the appellate practice class. And she has very strong opinions on that, as well as some really good questions, which maybe I'll share with the class at some point. But what I loved talking about my daughter, about the cases with my daughter, is that she is very independent-minded, and she will sometimes say that she thinks I'm absolutely right and sometimes say that I'm absolutely wrong. She doesn't hold anything back. After that process, I go back and I try to think about what am I going to say in response to the hardest questions that the court is likely to ask me. I don't know, however, whether my answers are any good until I move into the final phase of preparation, which is standing up in front of moot courts where lawyers in my office and outside my office, if we have another governmental agency involved, have read all the briefs, prepared the case intensively, and then pepper me with questions. And they are merciless. The moot courts can go on for more than an hour. I stay in roll. They stay in roll too, but within an hour you can really annihilate someone's position if they have selected an argument that just doesn't hold up. And the lawyers in my office take no small pleasure in seeing whether they can expose the flaws in an argument. After the moot court is completed, there's a deep breathing and discussion session at which the former pretend judges will now come back with affirmative suggestions about how to improve the argument. And after that moot court, I go home. I don't think about the case for that night because it's just something I don't want to think about. Regroup, take what I've learned, and go back and do it again.
So how many of those do you typically do?
I do 2 moot courts. I think you need to do at least 2 because the first is a dry run. You really don't know whether you understand your case until you are trying to answer questions that people ask you. The second one I try to make a little more polished, but I really don't want to peak too early. There's no point in giving the best argument that you can in the moot court. No points are given for that. I really would like to peak when I'm in front of the justices. So I let it go after the second moot court and try to be ready for the day of the argument.
So what do you take in with you? Neil referred to the fact that you don't seem to take many notes. What's on the podium with you?
On the podium with me is nothing in my current mode of arguing, but next to me at the table I will have, number one, our brief, because I always think that the one thing that you need to be accountable for, if you know nothing else, is what you have actually said to the court in your own brief. Any record materials in the form of an appendix or original transcripts with little flags on them of things that might come up that the justices might ask about, all within reach. A case, if a case is critical, with highlighted language, if I think somebody might ask me about a case, and statutory language or constitutional language if there is that kind of issue in the case. But up in front of me on the podium itself is nothing, because my view of oral argument is that it should be a conversation, and the only way you can really get a conversation going is by making eye contact and using all of the nonverbal means of communication that go along with speech so that it can be understood. The most fundamental rule of oral argument is that written speech and oral speech are totally different. You can do things in a much more complicated way with written speech than you can do with oral speech. In addition, with oral speech, you can use timing, pauses, doubling back on yourself to reinforce a point, which translates into a transcript that sometimes looks unintelligible, but everybody in the courtroom knows what you're saying. So my goal is to stand up, say what I think the most important thing is about the case, and let the justices take over, because it is their questions that are the most important part of the process. The sooner that I can get them engaged in the argument, the sooner that the argument will focus on what's really important, which is their views.
So 77 cases, I don't think we want to hear about all of them, but can you give us a couple of examples of really exciting or dramatic or surprising moments or peak moments when you peak just at the right moment or something along those lines?
Yeah, I don't know if I can have any examples of when I peaked at just the right moment. It's a difficult
maybe others are to judge for that, yeah.
Probably the most exciting moment that I did have in the court really had very little to do with me, but it had a lot to do with the case and with the appearance in the case of Justice Thomas. I was arguing the Virginia cross-burning case as an amicus curiae. The United States supported the state of Virginia. And the issue in that case concerned whether cross-burning was a form of free speech expressing a odious racial hatred, but nonetheless a protected form of expression under the First Amendment, or alternatively whether cross-burning was a form of intimidation that functioned as an illegal threat that inhibited people by putting them in fear. The court was questioning me closely about this, and Justice Kennedy and Justice O'Connor were having this dialogue with me about whether cross-burning really was like a threat and whether the threat had to be in danger of being carried out immediately. And I was having a very nuanced discussion with them about threats. Then all of a sudden, a voice was heard in the court that is rarely heard. Justice Thomas does not ask very many questions. And he came forward with a question in a voice that was later described by Slate magazine as the Luke, this is your father voice. And he said, Mr. Dreeben, aren't you really understating the threat posed by the burning cross? And I said, well, Your Honor, I'm attempting to. And he cut me off and he said, what I think you're trying to do is fit this case into our jurisprudence. And I was thinking to myself, yep, he's got me on that one. And he continued and said, but I really think it breaks the bounds of our jurisprudence. The cross, the burning cross, was the instrument of a reign of terror in the South for 100 years, and it had no expressive function. It was solely an instrument to suppress people. And his passionate statement was as galvanizing and as explosive as if somebody had set off a bombshell in the courtroom. It affected the entire tone of the argument. There wasn't any more discussion about subtle points of jurisprudence and the immediacy of threats. It completely changed the tone of the argument and put my opponent, Rod Smola, who's also a graduate of this law school, very much on the defensive, and he gave a brilliant argument notwithstanding, but nobody was listening to it.
Well, that's a great segue, I think, to allowing the folks sitting out there to ask you their own questions about your career or the cases in the court itself, the nature of oral argument. This is your shot, folks. I have other questions, but I'm thinking that you have some. Please.
To what extent do your answers to the judge's questions impact the way they decide a case? Because you mentioned that the brief seemed to be the predominant form for them to decide. So do they come there already like, I'm going to go this way and I'm just going to ask more questions in a certain way, or are they really seeking answers that will really change their mind?
Well, the questions in a Supreme Court argument serve many different functions. Probably the most notable function that questions serve is efforts to influence other justices on the court. In a multi-member court like the Supreme Court, there's no pre-argument conference. The justices all come to the court without having engaged in any real discussion with each other about the case. So this is their first chance to put forward their views. As a result, many of the questions that are asked in a Supreme Court argument are really signaling questions between the justices. Some questions are actually probing for limits of principles that you have not made clear in your brief. When Justice Alito spoke to this classroom, he said that in the brief, you can run, but in the oral argument, you can't run, you can't hide. You need to answer the questions that the court asks. And as a result, if you have been attempting to avoid some of the more difficult implications of your argument, in an oral argument, you will get asked those questions. And sometimes the way in which you handle those questions can reveal to the court the principle that you're espousing is too broad, or alternatively, the principle that you're espousing actually is quite workable. They may not have seen that before. The main influence that you can have as an advocate, I think, though, is not on the bottom line, but on the way in which the court articulates the bottom line. What facts it sees as important, what alternative legal theories it thinks are the most likely to be the best opinion for it to write. Yes?
Following arguments the day after, do your opinions of what were the key portions of oral arguments seem to mirror those that are mentioned usually in media accounts, for example, by Adam Liptak or Linda Greenhouse before at the New York Times?
Sometimes they do. The reporting on Supreme Court cases actually is quite good in many instances, and the reporters make an effort to talk to people who were involved in the case in order to have a sense of what was important and what was not important. The reality, though, is interpretation of a Supreme Court argument is like reading bones. You know, it's not an exact science. Different people will have different views about what was really important. For example, I went to the Supreme Court arguments this term on the funeral protest First Amendment issues, and the reports on that were all over the map about how the court was going, how the court perceived the case, which justices were inclined to vote in which way, and I had very different perceptions than those articles from having sat in the court. But in general, I think that you can get a decent flavor of what's happening by reading the articles. Now, of course, you can read the transcripts online, and even better, this term, for the first time, the court is making available the oral RAL presentations by the advocates online, and you can listen to the argument and you can make judgments for yourself.
Yes.
You've served in the office for some time now, under several administrations. I'm curious how their ideology impacts your job, or how insulated you are.
Because the Solicitor General's office is part of the Justice Department, we're not insulated in any formal way. The Attorney General is a political appointee, the Solicitor General is a political appointee, there's one other official in our office who's a political appointee. All the rest of us are career. That said, administrations tend to be very respectful of the role of the Solicitor General in trying to formulate the best long-term positions for the United States in the Supreme Court. For most areas of law, there are long-term institutional dynamics that govern what position the United States takes, and it does not change administration to administration. In fact, the most recurrent theme that I've seen is administrations adopting positions of their predecessors that they may not have adopted as an initial matter, but they do that in order to preserve the credibility of the Solicitor General's legal arguments. If we flipped our arguments every time a new administration came into power, the court would quickly begin to perceive our briefs as political filings rather than as legal filings, and that would be to the long-term detriment of the United States. At the same time, certain issues for every administration are high-profile political issues in which it's important that the administration put its stamp on what the government is saying to the Supreme Court. The Dickerson case that I described to you earlier was probably one in which the administration's position, as adopted by Attorney General Reno, Solicitor General Waxman, and President Clinton, is not the same as would have been adopted by any of the administrations that came before or after. There was a lot of controversy over the years about whether Roe versus Wade should be overruled, and administrations took strong positions on that, and the filings that the Solicitor General made reflected those. But the biggest influence that any change in administration has is it means that there will be a new Solicitor General. And the personality of the person who is the Solicitor General has a tremendous influence on the day-to-day functioning of the office, just because the personality of who your boss is matters. Yes?
Do you ever take for granted that the justices understand the complexities of your argument and then are frustrated or surprised by seemingly obvious questions that they ask?
No, I think that the Supreme Court is an enormously sophisticated institution, really an amazing place to argue cases. Before the argument has occurred, they have read the briefs, they have had memos from their law clerks and discussions with their law clerks that illuminate the nuances of the case. They're steeped in most of the areas of law that come before them, enough so that they're not going to be making any kind of routine, naive errors in perception of the case. And what is really most astonishing is how often the questions really go to the heart of the case, sometimes more deeply than the advocates have actually seen the issues. So it is a daunting challenge, but also a pleasure to argue in the Supreme Court. They are ready for you every time. Yes?
You say you represent the interests of the United States, but you're really representing the executive branch of the United States. Does anybody represent the interests of Congress before the Supreme Court?
We do. Most cases do not involve separation of powers conflicts, and so let me put those aside and talk about them in a separate category. There is a tradition in the Solicitor General's office that is summed up in the somewhat misleading phrase, duty to defend the constitutionality of statutes. The government approaches a case in which there's a constitutional challenge to an act of Congress with the view that the government will defend its constitutionality if reasonable arguments are available for that purpose. The reason why the government does that is precisely the point that you made, to give the people of the United States through Congress their voice in the Supreme Court. Not just the independent view of the executive branch of how that case would be decided if we were judges or justices. We're not. And we are attempting to give the fairest possible hearing to an act of Congress to the court, even if our best legal judgment might be contrary to the constitutionality of that act of Congress. We're not perfect surrogates for Congress, but we do adopt that philosophy. In areas of statutory interpretation, most often there's some agency that's entrusted with the administration of a statute. Our office will tend to defer to the views of the administrative agency on how that statute should be construed. That has a substantive component to it because an administrative law principle called Chevron provides for deference in the interpretation of ambiguous statutes to the agency responsible for it. But it also has one of institutional reality. We, as the Solicitor General's office, are not appointed to make policy for the entire United States. We are representing other actors in the government before the Supreme Court. Now, the one exception to that is where there is a clash constitutionally between the powers of Congress and the powers of the executive branch. In that instance, the executive branch has the option, although it will not necessarily take the option, to assert a position that the act of Congress is unconstitutional because it infringes on executive branch prerogatives. When that happens, Congress has provided for a mechanism for it to file its own brief in the Supreme Court to defend its own prerogatives so that the court gets a full view of these things. But the statute that empowers the Solicitor General to act says that the Attorney General and the Solicitor General shall represent the interests of the United States in the Supreme Court. And the Supreme Court has construed that phrase, interests of the United States, to embrace all three branches of government, and we take that responsibility very seriously. Yes?
Aren't you sort of faced with policy questions such as, like the decision whether to appeal don't ask, don't tell? I mean, I'm assuming the Solicitor General, the President, is involved heavily in that decision, which ultimately, to me, seems to be a policy question. I mean, and so when you're confronted with something like that, does the President get together with his advisors to decide what he wants to do, or does he look more broadly at Congress or the other sort of administrative agencies that are making supposedly policy decisions?
Well, let me preface this by saying I will not comment on any particular decision or any internal deliberations on a particular case, but I can talk about the principles that would guide the decision on whether to appeal an issue that has policy resonance to it. By institutional design, in the first instance, the Solicitor General is the decision-making official for whether the government will appeal. The way that that process works is a expression writ large of the process that I described earlier when the United States is deciding whether to appeal from a ruling suppressing evidence and some individual United States Attorney's Office wants to appeal and other people think that that might not be such a good idea. Dialogue occurs within all of the affected components of the Justice Department. So if there is an agency involved, someone in the Justice Department will reach out to that agency. Its views will be conveyed to the Solicitor General's office. If there's disagreement among components, very often a meeting is convened at which all the views are expressed on what the government should do. We have some guiding principles that help limit pure policy determinations from being made in situations where the administration may have a policy that points in one direction, but an act of Congress points in another. The most important one is the one that I described earlier, the duty to defend. The tiebreaker in these situations, absent an infringement of an executive branch prerogative, is that the government will put forward reasonable arguments if they are available for that purpose. And it is then the duty of the court to decide on the legal issue. If we abandoned the duty to defend, then we would be much more vulnerable to policy arguments. You shouldn't defend this act of Congress. It's contrary to the policy of this administration. And you would end up with the executive branch interfering both with what Congress is attempting to accomplish and with the role of courts in deciding the ultimate constitutionality of an act of Congress. So to preserve the separation of powers, we follow this prudential principle. Now, can it be abandoned or overruled? Well, the Solicitor General works for the Attorney General. The Attorney General works for the President. If the President wants to arrange for a particular position to be taken, the President has that authority and can carry it out. And in very rare instances, the President of the United States has determined the legal position of the United States. sometimes contrary to what a Solicitor General wanted to argue. But for all of the reasons why the Office of the Solicitor General was created, presidents usually respect its ability to reconcile the competing interests in the appropriate manner for the United States as litigant. Not necessarily for the United States as sponsor of legislation in Congress, or for the United States as an administrative body in administering a law, but for the United States as litigant, the Solicitor General's application and adherence to fairly neutral, long-standing principles is what's been deemed to serve the government best in the long run. And believe me, these discussions can get very heated, and they occur within the halls of the Department of Justice, and there are debates. Should we engage in the duty to defend here? Should we depart from that? What does it mean? All of these questions have nuance and depth and history and tradition, and they're shaped and reshaped with each new controversy that reaches the office.
And your office has a surprising institutional memory because several of the deputies have been there so long.
I have been in the office for 22 years, and I've been a deputy for 15. I'm not the senior deputy in the office, though. Ed Needler is the senior deputy, and he's been there more than 30 years.
Since the day I left, yeah. Because he took my office the day I left. So.
Practically since the dawn of time.
Yeah, the Pleistocene, yeah, yeah.
He has an enormous memory and an enormous knowledge of the workings of the government that is truly phenomenal. It's a resource that is unparalleled. And he serves as a wise repository of how have things happened in the past. New Solicitor Generals don't have to defer to what has been done in the past, but at least this way they know about it, and they are conscious of either working within a tradition or redefining that tradition.
I think we might have time for one more. Yep.
Knowing that you're trying to be concise and credible in preparing a brief, how do you decide what to include and what to exclude? And knowing that at least Justice Alito is looking for the weak spots, how do you reconcile all of those competing things when you're writing?
When you're writing, you don't. When you're writing, you just put down what you think needs to be in the brief. It's when you're editing that you make the judgments about what can come out. And you really need to be somewhat ruthless with yourself as an editor. You need to look at every sentence, every footnote, every word, and ask, is it advancing the point of this brief? I have seen briefs where you could literally cross out every other sentence, and the brief would say the same thing, and say it better and more efficiently. It's quite remarkable what you can do if you set your hand to making the burden of proof fall on every sentence to justify its existence. And as far as the question of what do you confront and what do you not confront in the brief, that is a process of judgment. It's not reducible to any formulas. It's a good first objective to say you should address those critical points on which the case will probably turn, even if they aren't strictly necessary to the resolution of the case in front of the court. They may be cases that will be right at the margins of the questions that the court will decide, and how your case affects those cases may be the most important thing that happens. In the government, because we have many interests that we want to protect over a long period of time, there may tend to be more footnotes that talk about peripheral issues than would be appropriate if we were just representing a single litigant and our job was just to win one case and then move on. But in any brief, you should address those things that are necessary to be addressed to satisfy the court's sense that this case can be decided in a way that is not only in accordance with the law, but is just as a common sense matter, and you should leave out everything else.
Well, I think that is a great note to end on. Please join me in thanking Michael Dreeben.
Produced by Duke University. Online at duke.edu.